Good morning, students. Today we are discussing the concept of Companies Act 2013 in respect of winding up of the companies, in respect to the types of winding up of the companies. One is voluntary winding up of the company, other is compulsory winding up of the company by the order of the court or by the order of the tribunal. Today we're concerned only about the voluntary winding up of the companies. So voluntary winding up occurs when the company directors or shareholders of the company decides to officially wind up the business of the company due to various reasons and various grounds, including loss of profitability or inability to pay debts. That is a process involved in the voluntary winding of the company in the cases of the company not able to run its business in profits but incurring losses in the last 5 years. And when company is not able to pay its debts to the creditors of the company, not able to pay their debts on time to the creditors of the company, lenders of the company, or to the debenture holders of the company, to the bankers of the company, not able to pay their dues and loans and advances and interest and loans and advances on time as to the company in the last 5 years. The condition is not good to continue. Company incurring losses, not profits. In these particular circumstances or cases, the directors or shareholders of the company may decide to wind up the business of the company. That is a voluntary winding up occurs when these persons need to decide for the winding up of the company, including loss of profitability or inability to pay debts of the company. That is this is just a small introduction of the voluntary winding up of a company as per Companies Act 2013. So types of winding up is two. One is voluntary, another is compulsory. So voluntary winding up takes place when a company becomes insolvent. That is a condition of voluntary winding up. In the case of insolvency of the company position is not solvent, it is insolvent. Company may be declared insolvent by the court of law or bankrupt by the court of law and is unable to pay off its liabilities on time, discharge its liabilities on time, to carry out voluntary winding up of private limited companies procedures. A winding up meeting need to be called when a resolution is passed to carry out the winding up procedures of the company. The creditors of winding up meetings should be held either the days fixed for general meetings or the very next day. That is a procedure involved in the winding up of the company. When the company becomes on time, that is the case. And to carry out voluntary winding up of the private limited company, a procedure of winding up is need to be called. A meeting has to be called and the resolution has to be passed by the members of the company or shareholders of the company to initiate, to carry out, to start the process involved in the winding up of the company. And the creditors winding up meeting should be held either on the days fixed for general meeting on the same day or on the very next day of the general body meeting, general meetings of the company. So creditor meeting has to be called for the purpose of winding up of the company. So this is a procedure involved in respect of the winding up of the company. Voluntary winding up takes place when the company becomes insolvent, when the company is not able to discharge liabilities on time. These are the conditions when you have to call a meeting of the members of the company, directors of the company, and you should also call a meetings of the creditors of the company. Maybe on a day of the general meeting, so which in that day when you call the meetings of general meeting for the purpose of voluntary winding up, or on the very next day of the general meeting to creditors meetings of the company for the purposes of winding up of the company. That is a case of voluntary winding up uh, by the members or directors of the company. So as per the procedure for winding up of a company in India, the notice for this creditors meeting should be sent by post to each of the creditors while one is sending notice for the general meeting. So notice has to be made for creditors meeting. Either it should be sent by post to each of the creditors of the company while one is sending a notice for general meetings of the company. And it should also be published in official gazette and two newspapers which are popular in the district where registered office of the company, head office of the company, domicile place of the company is located. That is a procedure for binding up of a company in India. The notice has to be made to the creditors of the company, to the members of the company for the general meetings and of the company for to give approval for the funding of the company by the members of the company. So it should also be published in official gazette and the newspapers as well, which are popular in that particular district where the office is of the company is located, is situated. You can see. So, meaning is that whatever decisions you are taking in respect to incorporation of the company, in respect of expansion plans of the company, in respect to diversification plans of the company, in respect of discontinuation of the company, in respect to, you can say, winding over the business of the company, in that case, you have to call a meeting of the shareholders of the company, directors of the company, or you have to call a meeting. Another meeting has to be called with the creditors of the company for the purposes of registration, for the purposes of winding up of the company. That is the case of voluntary winding up, and that must be notified. That it has to be notified in the official gazette as well, and it must be notified in the newspapers also, so that everyone have information in respect to winding up of the company. We are going to wind up very soon, but with the consent of the members, but with the consent of the creditors of the company, then company can start initiative process of winding up the company. So this is a procedure. This is a procedure involved in the case of winding up the company. That is very important from also from for the company law students. That is a last step in the uh, in the process of the company for the formation, incorporation of the company, formation of the certificate, commencement of business, doing business, and then company at the end, the last process of the company, which is a company, how company is going to end, how company is going to close, shutting down its business, discontinue its business activities, or dissolve its business by voluntary winding up procedure by the members of the company. Then voluntary winding up is a process. It is a process where the shareholders of a company voluntarily decide to wind up the company due to various reasons, such as expiration of the company lifespan, inability to carry on the business of the company, or the realizations of the company objectives. That is the case of voluntary winding up. That is a process of voluntary winding up. The shareholders of the company voluntarily they all decide, the large number of shareholders of the company voluntary by their wish, willingly they decide to close the business of the company, business operation, its subsidiary companies, its affiliate companies, whether holding by nature, subsidiary by nature, they decide voluntarily, they all decide with their consent to discontinue the business of the company, and to due to various reasons such as expirations of company lifespan, inability to carry on the business of the company, or the realizations of the company objectives. In that case, the, uh, the the members of the company may demand for the voluntary winding up of the company. So the process of voluntary winding up is regulated by the Companies Act 1956, that is the previous company law, and it is now replaced by the new Companies Act 2013. So voluntary winding up is a process which I already explained to you. That process initiated by the shareholders of the company in the meetings of the shareholders meetings or annual general meetings or general meetings of the shareholders of the company, and they all decide to discontinue the business of the company on the expiry of the company lifespan. If your company is incorporated, registered for a particular period, for 2 years, 5 years. So after completion of that period, the members may voluntarily decide to discontinue the business of the company. So after such as expiration of the company lifespan, the company is incorporated only for 2 years, only for 5 years, only for 10 years. And after expiry of 5 years, after expiry of 10 years, the company is going to discontinue, going to end its business after expiration of the license of the company. In that case, company business has come to an end. Company has to go through the formalities in respect of winding up of the company. Uh, if company is incorporated, formed for a particular duration, in that case, voluntary winding up procedure is initiated, and meeting has to be called with the debtors, with the creditors of the company and with the shareholders of the company. Separate meeting has to be called with the shareholders of the company and creditors of the company. Next case is when company is not able to carry on business. When company is not able to realize the company objectives, that is the case, that is the ground of voluntary winding up. So these are the grounds of voluntary winding up of the company, and it is regulated by the Companies Act 1956. Now it is replaced by the new Companies Act that is amended in the year 2013. That is the latest Companies Act 2013. Then come to circumstances of voluntary winding up. In which circumstances, in which conditions, on which grounds, when company may wind up voluntary. So company may be want a voluntary if the company in general meetings passes a resolution requiring the company to wind up voluntary as a result of the expiry of the period for its duration, if any, fixed by its articles, or on the occurrence of any event in respect of which the articles provide that the company should be dissolved. If the company passes special resolution, then the company would be wound up voluntary. Just I explain these terms in line sentences. The circumstances mean the conditions in which a company means a public limited company, private limited company, may be wound up voluntary. That is, a voluntary wind up is for the public limited companies. Again, voluntary wind up. The company may wound up voluntary if the company in general meeting passing a resolution to that effect, then company can start the procedure for winding up of the company after the expiry of the periods for its duration, if any, are fixed by the articles of association of the company. This is the first ground for circumstances, or on the occurrence of any event in respect of which the articles of association of the company provides that the company should be dissolved. So if that ground happens, if that condition happens, that circumstances happen, the company has to be dissolved as per the articles of association of the company, as per the grounds mentioned in the articles of association of the company. Company can initiate the process of voluntary winding up of the company if it is mentioned in the A of the company. So in the occurrence of event in respect of which A of the company provides you a power to dissolve, in that case company can voluntarily wind up by the members of the company if AOA so provides it's for the wind up. If the company passes a special resolution that the company would be wound up voluntary, in that case a company can wound up voluntary uh, wound up. So that is a case, that is a condition, that is circumstances, grounds for which the company initiate the process of winding up the company as per the Companies Act 2013 or as per the previous company law, previous Companies Act 1956. Uh, so for winding up procedures, whether in the form of incorporation or winding up procedures, meeting has to be called to discuss the important matters of the company, significant matters of the company. A meeting has to be called with the members of the company, shareholders of the company, to start initiate the process of winding up procedures. But for that, meeting has to be called. Meeting has to be called with the directors of the company, shareholders of the company, to pass the uh, resolution of voluntary wind-up. Then declaration of solvency. Declaration of solvency in case of proposal to wind up voluntary has to be given by the shareholders of the company, members of the company at the general meetings of the shareholders of the company or members of the company. And you have to declare your solvency, declaration of your solvency, that our condition is solvent, we are solvent, we are not insolvent, we are not bankrupt, we are able to pay our debts on time, we are not defaulters. To declare, in order to declare solvency in the case of proposal to wind up voluntarily, when it is proposed to wind up a company voluntarily, it is directors, or in the case of company has more than two directors, the majority of the directors shall at the meetings of the board make a declaration, verified by an affidavit to the effect that they have made a full inquiry into the affairs of the company, and they have formed an opinion that the company has no debt, or whether it will be able to pay its debt in full form, and the proceeds of assets sold in voluntary winding up. That is a declaration of solvency in the case of voluntary winding up, and when it is proposed to wind up company voluntarily by directors of the company or directors of the company or members of the company, or in the case of company has more than two directors, the majority of the directors at a meeting of the board make a declaration verified by an affidavit to the effect that inquiry into the affairs of the company and have formed an opinion that the company has no debt, and company will be able to pay its debts on time and proceed their assets on time, but company wish to discontinue. In spite of the solvency position, company wish to discontinue its business. That is a case of you have to declare your solvency positions. You have to declare that a financial position is very sound, very solvent, not insolvent, not bankrupt. You have to declare your position, but still, in spite of that, you all wish to have consent as the members of the company, as the directors of the company, to discontinue the business of the company. Uh, even the company is in a condition to continue, company is already in position to continue, but still company does not wish to continue anymore as a company, as a corporate entity. So in that case, with the consent of the members present in the meeting, by passing a resolution in the meeting, the uh, the company, the members of the company may declare for the voluntary winding up. Meetings of creditors of the company has to be called for the uh, voluntary winding up of the company, and just to propose to cause a meeting of its creditors either on the same day or on the next day, shall cause a notice of such meeting to be sent by registered post to directors, creditors of the company, with a notice of the meeting of the company under section 304. So the company shall, along with the calling of meetings of the company at which the resolution for the voluntary winding up is to be proposed, cause a meeting of its creditors either on the same day or on the next day, and shall cause a notice of such meeting to be sent by registered post to the creditors with the notice of the meetings of the company under section 304. This is section 304 of the Companies Act 2013. So along with the calling of the meetings of the company, for the purpose of passing resolutions for voluntary winding up of the company, meeting or creditors has to be called on the same day of the meetings when general meeting is called, or on the next day of general meeting is to be called, by giving appropriate notice to that effect to the member concerned, person concerned for the meeting, properly sent to the concerned persons and members of the company, either by registered post to the creditors of the company with a notice of the meeting under section 304 of the Companies Act 2013. That is, a meeting of creditors has to be called. Meeting is a very important part of Companies Act. Meeting is a very important part of company because company consisting of members, consisting of shareholders of the company, directors of the company, creditors of the company, members of the company, minority shareholders of the company, small shareholders of the company. So there are so many persons engaged with the company. So every time for taking any decision with respect to the company, whether it is small decision by nature, big decisions for the company, meeting has to be called. But that is a big decision to discontinue the business operation. And for this purpose, a meeting has to be called. Meeting we cannot ignore this section 304, and we have to follow the procedures of the Companies Act for the purposes of calling the meetings, issuing notice for the meeting, preparing minutes of the meeting, of the creditors meetings and shareholders meeting, and submit a copy of the minutes to the registrar of companies for record purposes, so that any person who wishes to see the records of the company can see the records of the company by payment of nominal fees to the registrar of the companies. And this is as per section 304 of the Companies Act in respect of the meetings of creditors. Then come to the again continuation of the meetings of creditors. Point number 2 in this, the board of directors of the company shall cause to present a full statement of the positions of the affairs of the company, together with the list of creditors of the company, penny, a copy of declaration in section 305. I'm just reading this line, and the estimated amount of the claims before such meeting. So the board directors of the company cause to be presented a full statement of the positions of the affairs of the company, means the financial position of the company, the trading profit loss account of the company, financials of the company, a cash flow statement of the company, funds flow statement of the company, counting of the company, annual reports of the company, explanatory notes of the company, working notes of the company, all the important, the bills and vouchers report, bills and bills payable, cash memo, cash books, and all the ledger books are properly prepared with, and presented a full picture of the financial position of the company with a list of creditors of the company, filing a copy of declaration under section 305, and the estimated amount of the claims before such meeting. Appoint one of the directors to preside at the meetings of the company. At least one director must preside the meetings of the creditors of the company. So point number 3 in this, where 2/3 in value of creditors of the company are of the opinion that it is in the interest of all parties that the company may be wound up voluntarily, the company shall be wound up voluntarily. The company may not be able to pay for its debts in full from the proceeds of assets sold in voluntary winding up, and pass a resolution that it shall be in the interest of all parties if the company is wound up by the tribunal in accordance with the provisions part of 1 of this chapter. The company shall within 14 days thereafter file an application before the tribunal. So where 2/3 in value of creditors of the company are of the opinion that it is in the interest of all parties that the company be wound up voluntarily, the company shall be wound up voluntarily. Okay, that is in 2/3 of creditors, value of the creditors of the company, and opinion that it is in the interest of all parties that the company be wound up voluntarily, and company shall be wound up voluntarily. That is a line. That is legal terms, legal lines. And this particular section, 2/3 of the in value of creditors of the companies is in the opinion that it is in the interest of all parties that the company be wound up. So in that case, the company may issue an order for the voluntary winding up of the company. Then point number B, the company may not be able to pay off its debts in full from the proceeds of assets sold in voluntary winding up, and pass a resolution that it shall be in the interest of all parties. In the interest of all parties, if a company is wound up by the tribunal in accordance with the provisions of part 1 of this chapter, the company shall within 14 days, that is the time limit, 14 days thereafter, file an application before the tribunal for the purpose of winding up of the company. Meaning is that when company may not able to pay its debt on time from the proceeds of assets sold in voluntary winding up, then pass a resolution that it shall be interested all the parties, the companies wound up by the tribunal in accordance with the provisions of this particular section, part of the Companies Law, Companies Act. And company shall within 14 days thereafter file an application with the tribunal to issue an order for the purposes of winding up of the company. Okay, that is the case of voluntary winding up. When company is not in a condition to pay its liabilities and dues on time, as it is used to the creditors of the company, lenders of the company, bankers of the companies, and other third parties liabilities too. In that case, if in the interest of all the parties, if the company is wound up by the tribunal in accordance with the provisions of Part 1. The meeting of creditors, point number 4. The notice of any resolution passed at a meeting of creditors in pursuance of this section shall be given by the company to the registrar within 10 days of the passing day. So, notice of any resolution passed in a meeting of creditors, it must be as per the Companies Act, as per the provisions of the Companies Act. Notice has to be issued to pass a resolution in the Companies Act for the purposes of voluntary winding of the company to the, and one copy should be submitted to the registrar of companies within 10 days of the passing of resolution for that effect, to that effect. So that registrar office have record of your resolution passed, already passed in the meeting. It is already valid in the meeting. The decision is already valid. It is valid because it is already passed in the meeting. So it is a valid resolution. It is confirmed resolution. It can be posed in the court of law in the case of any dispute, deliberations. Then publications of resolution to bind a voluntarily. When a company has passed a resolution for voluntary winding up and resolution under subsection 3 of section 306 is passed, it shall within 14 days of the passing resolution give notice to the resolution by advertisement in the official gazette of the company and also in newspaper, which is circulation and distribution registered office or principal office of the company is situated. So publication is very important. Publications of your resolution passed by the company is very important. To give notice to resolution by advertisement in the official gazette and also newspaper, where everyone have information in respect of the voluntary winding up. So it must be notified. It must be in the official gazette or also in the newspapers, circulated in the local areas. The district areas of the company, the office of the company is located situated. Um, so notice has to be given, and resolution passed notice has to be given to the members of the company and to the company as well, because company is a separate legal entity concept. Company is different, members are different. The copy resolution has to also be submitted with the company for the record purposes, for the information purposes with the company. So publication resolution is very important. You have to publicize. You have to inform your general public that this company is going to wind up very soon, because resolution has already been passed in the general meetings of the shareholders and creditors meetings of the creditors meetings as well. In that case, the company has to discontinue its business operation after the order has been passed by the tribunal for voluntary binding. Penalties provisions are there for publication resolution to voluntary wind-up. If a company contravenes the provisions of section 1, the company and every officer of the company who is in default shall be punishable with fine which may extend to 5,000 rupees for every day during which such default continues. So penalty provisions are there, penalties are there, fines are there, imprisonments are there, it is there. Then what is non-compliance of the provisions of the Companies Act 2013 in respect of publications of resolutions to wind up voluntarily. The penalty provisions are there, section 2 of the company contravenes the provisions of subsection 1. the company and every officer of the company who is in default shall be punishable with fine, which makes 10 to 5,000 rupees for every day during which such default continues, and commencement of voluntary winding up. A voluntary winding up shall be deemed to commence on the date of passing a resolution for voluntary winding up under section 304, that is the commencement of voluntary winding up. So, this is about the penalty provisions in respect of publication resolutions uh, in the newspapers, in the official gazettes of the company. And meaning is that to inform the company, to notify the company that company is going to end very soon, because approval is already obtained from the shareholders of the company, members of the company, the meetings of the company. So, voluntary winding up shall be deemed to commence on the date of the passing of the resolutions for voluntary winding up under section 304. Then there are effects of voluntary winding up. In the case of voluntary winding up, the company shall, from the commencement of the winding up, ceases to carry on its business except as far as required for the beneficial winding up of its business, provided that the corporate state and corporate powers of the company shall continue until it's dissolved. That is the effect of voluntary winding up. The company shall, from the commencement of winding up, ceases to carry on its business except the owners of the company, members of the company, and shareholders of the company. They ceases to be a shareholder of the company, they ceases to be a member of the company, because company is no longer in practice, no longer in service, no longer in the register of members of the register of the companies. Not registered, strike off from the register of companies, from the register of companies, and that is the effect of voluntary winding up as far as required for the beneficial winding up of its business, provided that the corporate state and corporate powers of the company shall continue until it is dissolved. Then come to the appointment of company liquidator. Very, very important point. You have to appoint company liquidator for the purposes of liquidation, for the purposes of liquidification, and for the purpose of winding up resolutions of the company. Company has to appoint official company liquidator as per the order of the tribunal. Tribunal here means National Company Law Tribunal or National Company Law Appellate Tribunal, that is NCLAT. The company in its general meeting, where resolution of voluntary winding up is passed, shall appoint a company liquidator from the panel prepared by the central government for the purposes of winding up its affairs and distribute the assets of the company, and recommend the fee to pay to the company liquidators. That is appointment of company liquidators. That is appointed by the tribunal, and shall appoint a company liquidator from the panel prepared by central government as per the panel paid by central government for the purposes of winding up the company, its affairs of the company, and for the purpose of realization of all assets and payment of all dues and liabilities, and pay the fees to the liquidator of the companies as should be appointed from the panel as decided as prepared by the central government for the purposes. The government may appoint the liquidators on the order of the tribunal to the company. So, vindicators having passed resolution for winding up the company under subsection 3 of section 306, the appointment of the company liquidator under this section shall be effective only after it is approved by the majority of creditors and value of the company, provided that where such creditors do not approve the appointment of such company liquidators, creditors shall appoint another company liquidator. So the creditors have passed a resolution for winding up of the company under subsection 3 of section 306. The appointment of the company liquidator under this section shall be effective only after it is approved by the majority of creditors of the company. Provided where such creditors do not approve the appointment of such company liquidators, creditors shall appoint another company liquidators. Okay. Meaning of this line is that again is explain this line clearly to all of you. You should listen to carefully and make a note of that. Make a note of that where the creditors have passed a resolution for every in the company, so every decision of the company taken at the meetings of the company, and this is a very important decision in respect of winding up the company, where the creators have passed a resolution to that effect in the creators meetings of the company for the purposes of winding up the company, and liquidators so appointed by the tribunals as approved by the majority of creditors in the value of the company, quite appear such creditors do not approve the appointment of such company liquidators. Creditors shall appoint another company liquidators. So, if creditors do not approve, the creditors of the company in their meetings, creditors meetings, do not approve the appointment of company liquidator, in that case, the creditors shall appoint another company liquidator. That is the meaning of this line as per subsection 3 or section 306 of the Companies Act of 2013 in respect of the appointment of company liquidators by the creditors of the company in the creditors meetings, and creditors do not approve the appointment of company liquidators. In that case, creditors shall appoint another company liquidator. Then come to the powers and duties of company liquidator. Powers and duties of company liquidators and voluntary binding of the company liquidator shall perform such functions and discharge such duties as may be determined from time to time by the company or the creditors as the case may be. The company liquidator shall settle the list of contributories which shall be prime facie evidence of the liability of the persons named to the contributories. The starting with the powers and duties of company liquidator in respect of the voluntary winding of the company liquidator shall perform such functions and responsible for the duties, responsible for the proper discharge of its duties and responsibilities as we determined from time to time by the companies or the creditors or as the case may be. That is the meaning of this line. Then point number 2, the company liquidator shall settle the list of contributories which shall be primary facie evidence of the liability of the person concerned to be named as contributories. Then point number 3, the company liquidator called the general meetings of the company for the purposes of obtaining section grants, approval, permissions of the company by passing a special resolution or ordinary resolution by nature, as the case may be, for the purposes or for another purposes, as he may consider necessary in proper discharge or fulfillment of their duties as company official liquidator, appointed for the purpose of liquidation, winding up and dissolution of the company. Then point number 4 in this, the company liquidator shall maintain regular and proper books of accounts in such form and in such manner as we prescribe, and the members and creditors and any officer authorized by the central government may inspect such books of accounts. So the company liquidator shall maintain regular and proper books of accounts. That is a duty, that is a responsibility, that is a responsibility of powers associated with the company liquidators for the purposes of winding up of the company. The liquidator is responsible for the maintenance of the books of accounts, proper books of accounts, as per the accounting standards, as per the net financial reporting standards, as per the generally accepted accounting principles and golden rules of accounting, double entry system. Account has to be prepared, and he is responsible for the proper books of accounts in such form manner as prescribed to. And the members of the company, creditors of the company, and any other officer of the company or try to settle government for the may inspect books of accounts of the company. Then company liquidator shall pay debts of the company and shall adjust the rights of the contributories among themselves to be contributed at the time of dissolution of the company, at the time of running of the company. Company liquidators shall observe due care and diligence in the discharge of his duties, proper care and and diligence in the proper discharge of his or her duties as a company liquidator, official liquidator of the company. So he must he or she must certify, must declare that a proper care and diligence must be followed during at the time of preparation of the books of accounts, and at the time filing of all the books of accounts and returns with the ROC of the company. That is required for the proper closing of the books of accounts of the company. Proper care has been taken care of and proper diligence has been taken care of by the company in respect of the dissolution of the company. That is a statement or declaration given by the company liquidator in respect of his or her duty of care and diligence. And if the company liquidator fails to comply with the provisions of this section, except subsection 5, he shall be punished with fine which may extend to 10 lakh rupees. The company liquidator fails to comply with the provisions of this section, except subsection 5, he shall be punishable with fine which may extend to 10 lakh rupees. Then come to the final meeting and dissolution of company. As soon as the affairs of the company are fully wound up, officially wound up, the closing of the books of accounts of the company, payment of dues of the company, realization of all assets of the company, and whatever balance left as surplus to be distributed among the members of the company in the form of share capital of the company. The company liquidators, official liquidators, shall prepare a report of the winding up, showing that the properties and assets of the company have been disposed of and debts fully discharged or discharged to the satisfaction of the creditors, and thereafter call a general meeting of the company for the purpose of laying the final binding of accounts before it giving any explanations therefore. So as soon as the affairs of the company are fully wound up, the company liquidator shall prepare a report of the winding up showing that the properties and assets of the company are disposed of in the manner as prescribed in the MO of the company or as per the company's provisions of the Companies Act, and therefore calling a general meeting of the company for the purposes of laying the final binding of accounts before it giving any explanations therefore. So, so we have to make a proper maintain books of account. Proper reports has to be prepared by the official liquidator in respect of the binding of the company, that all the accounts are cleared, all the debts are cleared by the company, all the payments has been made by the company, all the assets realized by the company, realization account is prepared by the company, and settlement of dues by the company. So within 2 weeks after the meeting, the company liquidator shall send to the registrar a copy of the final winding up of the accounts of the company and shall make a return in respect of each meeting and of the date thereof, and copies of the resolution passed in the meetings. So within 2 weeks after the meeting, the company liquidator shall send to the registrar a copy of the final winding up accounts of the company and shall make a return in respect of each meeting and of the date thereof, and copies of the resolution passed in the meetings. So this is about the procedures involved in what we call a final meeting in respect to dissolution of the company. Within 2 weeks after the meeting, company liquidator has to send a report of the meeting to the registrar of companies for the record purposes, to be kept for inspections and investigation purposes for the general public by the payment of nominal fees by the general public to the ROC.